Good evening, everyone. Thank you so much for being with us. Nice to see so many familiar names on the list joining the webinar this evening. I'd also like to say thank you to my colleagues Guy, Ben and Tess at 5 St Andrews Hill for having me this evening to chair the webinar for you. So as you are aware, we will be covering two very important topics, which is judicial review and appeals in fitness to practice proceedings. Just a couple of housekeeping things, please. We are going to have the Q&A box open. So if you have any questions for any of us, if you could pop them into the Q&A box and we will deal with those questions after the presentations. Also, the slides and recording will be sent out to all of the participants after, so you will have the opportunity to have them saved in your boxes afterwards. So don't worry about having to furiously scribble notes throughout the course of the webinar. So we're going to start with Ben. Ben was called to the bar in 2004. He specialises in cross-border and international cases and has extensive experience of appellate proceedings and is a leading barrister in the immigration and public law sectors, which is obviously very relevant for the topic he is going to be talking about this evening, which is a practical approach to judicial review. So we won't be speaking about all of the law. We're going to do a very practical, hands-on approach to this seminar to give you a really good overview of the topic. We will then move on to Guy. Guy was also called to the bar in 2004 and is a fitness to practice specialist, having loads of experience, over 16 years in the space, acting on behalf of individuals and regulators, so has that approach that gives you overview. Guy is going to be talking about appeals, and we'll be talking about his experience in both the High Court and the Court of Appeal, giving you a very good practical hands-on approach to how to deal with appeals, time limits, costs, etc. For those that don't know me, I am Shannett Thompson. I'm a partner at Kingsley Napley. I'm also a specialist in the fitness to practice arena, and I'm going to hand over now to Ben.
Thank you, Shannett. I'm also responsible for doing the slides as well, so any mistakes in the movement of slides is in mine entirely. Thank you for the introduction. What I'm going to deal with is a very brief, broad overview of judicial review proceedings, and to try and give you some of my experience of acting in judicial reviews, both for claimants and defendants. And how actually, I think one of the key things I want to try and emphasize is that there's a lot of the majority of judicial reviews, in my experience, actually don't get to court. And so there's a lot of litigation that not a lot of people get to see unless you do these cases quite regularly. I will list some topics of what I'm going to cover as an introduction, the process, what, who you're judicial reviewing. Is it what you need? Why you're doing it? What grounds are you dealing with it? Time limits, and a few of the stages that you might want to deal with. I've only got 20 or so minutes, so I'm not going to be able to cover everything in any great depth. What I'd like to give you is a sort of few takeaways as to how to decide whether or not you want to bring judicial review in regulatory proceedings. There's a document which I've stolen the flowchart from, which is the Administrative Court Guide to Judicial Review. It's quite a long, detailed document. It's very helpful. It sets out judicial review in great detail, and this is the flow chart from that guide, explaining the time limits that are put in place in terms of the service and filing of judicial review claims. We're going to deal with pre-action correspondence and settling claims in a bit later. But the first stage is to lodge a claim form. The defendant then has 21 days to lodge an acknowledgement of service, and in that acknowledgement of service, the respondent must place what are called summary grounds. The summary grounds give you an overview of what the defence the respondent or defendant is putting forward, and says why the claimant shouldn't get permission. Then permission is considered by a single judge on the papers. If it is granted, then you go to a hearing. If it's refused, then you can file a renewal notice, and then you can have an oral hearing at the High Court to explain why you should have permission to bring judicial review. And at that point, you have the opportunity to slightly vary or change the emphasis of what you're arguing. I'm not really going to do very much with the totally out merit points. Those tend to be cases which are repeat judicial reviews, usually in immigration proceedings, but sometimes in data protection proceedings where vexatious claimants bring repeated judicial reviews on the same point. And if they are totally without merit, that gives you no right of appeal. Guy's going to come and deal with appeals in the Court of Appeal later, but you can, if you are refused permission on a judicial review, you can also appeal that refusal of permission to the Court of Appeal. I'm not going to deal with that today, just going to deal with the judicial review aspect. And then obviously if you get a substantive hearing, then it's a decision on whether your claim is allowed, dismissed, and there are a number of different outcomes, which I'm going to come to in a moment as to what the outcome of the judicial review might be. But the first thing you need to look at is, before you start deciding on judicial review, is what are you trying to judicially review? Judicial review is usually of a decision-making body. Often government departments, but as we know, it is also statutory regulators and other regulators, which I'll come to in a moment as to whether they are subject or not to judicial review. But it can be a specific decision. So a decision to refer an individual to a committee, in a regulatory committee, for instance, might be subject to judicial review. The might is on two grounds. Firstly, it depends on whether you've got an alternative remedy, which again we'll have a discussion. I'll come to in a moment. And the second is whether the particular regulator is susceptible to judicial review or not. But you can also judicially review a failure to make a decision or a failure to follow a policy. And they're not quite the same thing, but where regulators or government bodies prescribe themselves a time limit in which they must make a decision, and they fail to do so, they have an ongoing duty to explain why. And if they don't do so, you can, in certain circumstances, judicially review them to make them make a decision, so that you can then have an appeal or a decision in which you can challenge in either a tribunal or a court. And those are usually set down in some sort of internal policies, sometimes external policies, which say, for instance, a decision must be made within a 3-month or 6-month time limit. And a failure to do so will sometimes be defined in the Constitution, sometimes be defined in statute, and sometimes won't be defined at all. And so it's a question of trying to analyse the different provisions that pertain to each individual regulator as to whether the failure to make the decision is judicially reviewable. The third main issue is policy, which is something that I don't think is done very much in regulatory proceedings, but is done a lot in other government proceedings, particularly in relation to immigration, but also in relation to data protection, because government issues policies or procedures which their caseworkers or decision makers have to follow. And that's pretty similar to the way that many regulators work. And so a failure to follow that policy, or a policy that is fundamentally wrong at its outset because it's either discriminatory, in breach of another piece of law, because it fails to engage with other statutory powers that the regulator has been given, or for some other reason, can be subject to, and we're going to come to discuss our social media policy very briefly at the end, could be subject to judicial review. In the same way, failure to follow a policy. And again, depending on the status of the regulator, it may be a failure to follow the Equality Act, or in some cases, the public sector equality duty may also give rise to judicial review. On top of that, there are human rights considerations, which bolt on or can be standalone issues as well. The question is therefore whether it's judicial review or appeal that you want to go for. Who are you judicially reviewing? Most, if not all, regulators, in my opinion, are subject to judicial review. I know not everybody agrees with that, but the High Court are quite reluctant to find that somebody doesn't have some sort of remedy to their case. Now, so there's a difference between being subject to judicial review and judicial review not being appropriate, because it might not be appropriate because you have an alternative remedy. You have a statutory appeal, for instance, in which the particular question that's in force can be challenged, or it might be that there is an effective, or at least nominally effective, internal referral procedure or appeal, which allows you to examine that particular issue in a different format. But you need to decide whether it's the whole body, whether it's a particular committee, particular individual, particular decision maker, and who you're going to judicially review. That's probably not a very difficult question, because you'll have a regulator and you'll be able to work out exactly which decision you want to attack. Or if you're a regulator, which decisions that you made might be subject to challenge. So is judicial review actually what you need? Is there an alternative remedy? And judicial review will often be refused because there is an effective alternative remedy. And that will really depend on the appeals procedure. So if particularly the statutory regulators have statutory procedures and statutory criteria that are followed and questions that must be answered by the High Court. But there might be some issues, for instance, the social media policy, which we're going to come to, which isn't defined at all by statute and doesn't actually directly necessarily impact on the statutory framework, but is a policy or a procedure that has been implemented by the regulator that might be subject to challenge for human rights reasons or Equality Act reasons or other reasons. But so the first thing you need to do is see whether there is some other mechanism, some other appeal or review function which allows the particular decision or the failure to make a decision or the policy to be reviewed out with a judicial review. Once you've done that, you need to decide what your outcome wants to be. So you need to look at why are you judicially reviewing and what do you want the outcome to be? And there are three outcomes. You can get a mandatory order, a prohibitory order, or a declaratory order. I'm not really going to deal with the fact-finding powers of the High Court, but in judicial review, there is some debate about how much power the High Court has to make fact-finding challenges. But it does retain the power to substitute its own decision for the decision of a decision maker if it so chooses. But your mandatory order might be you must go away and review this. You must take this policy and you must review it and check that it complies with these particular duties, and you haven't done so. So failure to properly consult, for instance, in a government policy might be an issue, less so with the regulators, but it might be that you have to, having heard all the evidence and the law, that the mandatory order is that a different decision must be made along the following lines, and that a decision is substituted by the High Court. Could be a prohibitory order, less likely in regulatory proceedings, but there might be occasions where it's necessary to prevent a particular referral or a particular action being taken by the regulator until certain other actions have been done or until certain time limits have passed. And declaratory, which again is not used that much, but on its own, but is a very useful tool in that if there is a particular provision, either statutory or within the constitution of a particular body, you may want to go to the High Court to get declaratory relief about what the meaning of a particular part of regulators' codes, practices, etc. mean. And that can also be done in civil. I've seen that done in civil cases as well. For instance, I've done cases in relation to interpretation of the constitution of various religious charities and how those different provisions interact. And so that is that's something a regulator could bring as well as an individual, because that declaratory relief might then give clarity to the actual decisions that are being made or the particular policy that has been implemented. What grounds are you going to use? There are many iterations of the different grounds that you can use, but essentially these are the main ones, which is the decision unlawful? So it is against a piece of law. That can be, again, it can be specific statute that governs the regulator. It might be data protection law. It might be a breach of natural justice. Unlawful decisions are often clearer cut than many, and many of them, in my experience, settle. Unreasonable. The Wednesbury Picture House test is the decision so unreasonable that no reasonable decision maker could have made it. That is something that may well feature quite strongly in challenges to committees of regulators. For instance, the decision to institute an investigation or to refer a regulated person to a further committee or to a further investigation or to a panel to consider that. And that can also then feed into irrational. So often irrational and unreasonable overlap, in that there is a duty to give, particularly in public law proceedings, and particularly in regulatory proceedings, to give reasons as to why certain decisions are made. And a failure to give reasons can be either unreasonable or irrational. So just because a decision has been made, you have to justify, you have to explain why the decision was made, and it has to be decision has to be reasonable. But you'd be surprised how many decisions are made which are very short, don't really provide proper reasoning, and don't really explain why a particular decision has been reached. For instance, I've seen some SRA cases where the SRA have looked at decisions to refer to an independent adjudicator, but the independent adjudicator is in fact a member of the SRA. Question whether in fact that was a reasonable or irrational decision, and then whether in fact that was going to make a difference to the decision overall. And then finally, breach of human rights. Whether the body that you're judicially reviewing is a public body and therefore must comply with the Human Rights Act, is obviously, once you're in judicial review, then they would almost certainly have to comply with the Human Rights Act. And then whether or not you might get some damages for that, it's quite unlikely, and that's often not probably not something you're going to deal with. But you just never know when that might come up. But they all overlap to a degree, and it's trying to work out precisely what decision you're judicial reviewing and which of those grounds is the best to use, and what facts you're going to use to examine them. Time limits in judicial review. I know Guy's going to talk a bit more about statutory time limits and Polikowski and Zaprachenko and or lots of other cases like that which deal with strict time limits. In judicial review, the second question I always ask a client is, are you within 3 months time limit of the decision that you want to make a judicial review of? Because if you're not, then you've got to have a really good reason why you missed the 3-month deadline. Because it can be from 3 months of discovering that a particular act took place, because you might not have been informed by the regulator, but the decision might have been made on the 1st of January, and you're not informed until the 1st of April. Time would then generally start to run from the 1st of April, but you would probably have to tell the court that you're judicially reviewing the decision of the 1st of January, but you didn't discover it until the 1st of April. So it's not automatically extended. You have to make an application to the court for that to take place. Or is it in fact a continuing breach? Is it something that has continued from the outset, and as a result means that you need to intervene? And I'm running slightly out of time, so I'm going to race on. The thing I'd really like to emphasize is that the many judicial reviews are settled, and for applicants is quite low cost and low stress to launch a pre-action protocol letter, because that will often trigger a proper decision analysis process and a litigation risk analysis by a regulator as to what the risks are of actually going to judicial review, because they are risks. The risks for defendants are often quite high in judicial review, because actually cases are often not very clear cut, and there is a risk that the law may be changed, or a risk that they may lose with cost implications. And actually, it's much easier to respond to a pre-action protocol letter and decide to either settle the case or to make a new decision. And so, I probably have half a dozen judicial reviews going on at any one time, and I would suggest that only 10–15% of those actually ever get into a courtroom to have a final decision on. And so it's very worth thinking about what your challenge is and how you're going to define that in your first pre-action protocol correspondence. We've dealt with what the grounds are. I've dealt with the AOS. I'm going to rush through these last bits. I've given you the flow chart, and then maybe at the end we'll have a quick discussion about the social media policy, which I'll put in an example, which is really sort of to give you an illustrative example of a short policy that probably hasn't been well thought out, but might, in my opinion, be subject to judicial review on a number of grounds. But I'm going to leave that perhaps to the end, because I want to give Guy some time to deal with appeals and others. That's sort of the costs very quickly. The costs implications, the loser usually pays judicial review costs, but costs are usually very limited in the acknowledgement of service stage. So if you get to a permission stage, you're only entitled to reclaim the costs of the preparation of the acknowledgement of service, which is only usually it shouldn't be a huge amount of work. It shouldn't be more than, well, a few hours. For counsel, probably 5 or 6 hours, plus solicitor 10 hours. So 15 or 20 hours of acknowledgement of service is the high end of an acknowledgement of service. And so the court will not routinely allow large costs at the acknowledgement of service stage. So that's something else to bear in mind. Sorry, I've gone slightly over my time, but I will. I hope that's been useful, and I'll hand over to Guy for the next section.
Thank you so much, Ben. Before we hand over to Guy, we have noticed that there is one hand up, Andrea. We just wondered if there was a question that you wanted to raise with Ben now, or if not, we will pass on to Guy. Okay, I think that's probably not a question at this stage. So, Guy, over to you to deal with appeals, please.
Thank you very much indeed, Shannett. As has already been said at the outset, the fundamental thrust of this webinar is not to spend too much time talking about the law. We're all very familiar with the law, and we regularly keep in touch with the reported cases. What certainly the intention of my talk is to do is to touch on some of the key procedural elements of proceedings before the High Court and the Court of Appeal, albeit not to do so much in what I say during this webinar, but you'll find them in the in the slides that are going to be circulated after this webinar. But to look at some of the key practical points that arise during the course of litigating appeals, and to explore how they may be best addressed in order to hopefully make for a more effective but also slightly less anxious litigation process. So can we start, please, with the first slide on time limits? So the first thing to recognise when it comes to fitness to practice appeals is that the time limit is set by the enabling legislation. It's not a time limit which is dictated by the CPR. And that's important because it means that the very first hurdle, and one that a number of particularly litigants in person can fall short of right at the very outset, is ensuring that the appeal has been filed in time. As I say, the time limit is determined by the regulator's legislation, and so that means that unless the legislation provides for circumstances where the court can extend time, it doesn't have the power to do so. There are a couple of exceptions to that. General rule that 28 days is the time limit and there's no power to extend, and they apply for the GDC and the General Pharmaceutical Council, but I think that's essentially it. The court does, however, have a very limited power to extend time in order to ensure compliance with Article 6. But that is a time limit that may be extended only in the most exceptional circumstances. And essentially the test is, if court were not to be extended, time were not to be extended by the court, would that impair the very essence of the right to an appeal? And the leading case on that at the moment is Court of Appeals judgment in Stewie and the Health and Care Professions Council. If an extension is granted, then it has to be to the minimum extent possible. And the reality is, in the rare circumstances that extensions have been granted, and I can only think of one case where the High Court has ever granted an extension, then it's only going to be for a matter of days, and that could even be for just 1 or 2 days. So given how restrictive the court's approach to out of time appeals is, what do you do if you're in a circumstance where you have an appeal to file, but it's really not ready to go? It may be, for example, you haven't secured representation, you haven't got a transcript, you haven't come to a final view as to whether or not it's an appropriate case for an appeal. The simple answer is to get on and file it, because that way you can at least secure jurisdiction. And at that point, there are steps you can take to, for example, add or amend grounds, to add documents, to seek representation if you have yet to get it, which are simply out of reach for you if you didn't file the appeal in the first place. And it's something, therefore, I would suggest is the advisable course to take if you're at that point of not quite being ready, or indeed not even particularly close to being ready to present your appeal by the time that the time limit is about to run out. From the regulator's perspective, if an appeal has been filed out of time, then the duty really is on it at that point to seek to strike the appeal out. If the regulator lets the whole appeal run all the way to the final hearing and then makes the application at that point, when significant costs and court time have already been incurred, then that's likely to result, assuming the application is successful, with a fairly punitive approach by the court towards any costs application that is made. There's a benefit also, of course, to the regulator in ensuring that the litigant in person, if it is a litigant in person, gets the opportunity to put their arguments for extending time at an early point during the process. And secondly, also to reduce the regulator's costs and hopefully bring the proceedings as a whole to an end much more quickly than would have been the case if everything had moved on to a final hearing. Next slide, please. The next issue to consider if you are acting for an appellant is costs, and whether or not there is any opportunity available to seek to reduce the cost risk. Now, there will be many for whom this power, which the court has, is unlikely to be of assistance. Those, for example, who are personally relatively well off, and those who have the benefit of indemnity and insurance cover, and who otherwise have a reasonable amount of money behind them. However, there are always those, not merely litigants in person, for whom they are facing not only the devastation of their career, but also don't have the money to be able to fight an appeal and risk losing it. So if one is a relatively impecunious appellant, then this is potentially a way to allow them to access making an appeal, which they could not afford to lose. And it may be, for example, that this is of particular relevance to professionals such as social workers or nurses if they do not have the support of a union body or otherwise. Now you'll see there on the slide the factors which the court is obliged under the CPR to take account of. In reality, when it comes to the practicalities of this, a court is most likely to look favourably on applications if the following factors are present. Firstly, a substantial imbalance of resources. Well, that is likely to be present in most cases because the regulator clearly has substantial resources. Secondly, there will be serious consequences to the appellant, and so therefore the more serious the sanction that had already been imposed in the original proceedings, the greater the weight is going to apply to this factor. So clearly if the appellant has been erased, struck off, or suspended for a significant period of time, then that's going to carry more weight than an order for conditions. Thirdly, a significant lack of personal resources. That's obviously right at the heart of this. Fourthly, whether or not there's a real prospect of success. That does appear to be a factor that the courts will take into account. And then finally, the amount of costs the respondent is likely to incur in defending the appeal, subject to that aspect of the appeal that they're incurring costs in respect of having a real prospect of success, because that's going to feed into the costs exposure that the appellant is going to face. Now, this is not an application really that can be made before filing the appellant's notice. It's an application to be made at the same time. There's a space on the appellant's notice itself to make that application, and it will need to be accompanied by a witness statement dealing with the points above, and I'd suggest relevant documentary evidence supportive particularly of demonstrating the financial position of the registrant. The appellant needs to appreciate that, as is shown by the facts in the Greg Wallace case, that they're unlikely to be allowed to have their cake and eat it. And if they win, then it's likely that the court is going to constrain their own ability to be able to recover costs in any event. However, what that does, of course, achieve is it takes the gamble out of the litigation, and it allows the appellant to at least have a good idea up front what the litigation is likely to cost them. Moving on to the next slide, please. We can just go back one, please, Ben. Thank you very much. So a very, very quick whistle-stop tour of the relevant provisions. The appeals are governed by Part 52 of the CPR. There's two practice directions that you need to be very familiar with. The first is practice direction 52D, because that's the one that deals with statutory appeals, which these appeals from fitness to practice decisions are. But also you need to be familiar with practice direction 52B, because that deals with the real nitty-gritty of conducting an appeal in the High Court. So even though it's written within the context of appeals from in civil litigation from lower courts, it does actually apply to no small degree for statutory appeals as well. Whether permission is required, of course, is determined by the legislation enabling the statutory regulator, and the vast majority of them, I think not all of them, don't have a permission requirement. In terms of what you need to file when filing the appeal, you need to file your grounds. You need 3 copies of the appellant's notice plus a copy for each respondent. Any applications which you need to make should be made at that point, ideally. So that would go along with things such as applications for anonymisation, extension of time, etc., etc. Make sure you file with the correct fee, because if you haven't filed with the correct fee, then it doesn't count, and you'll find yourself in the difficulty that a number of people have found themselves in the past, which is that because they haven't filed with the correct fee, they're not deemed to have filed the notice, and if time runs out, then that's pretty much the end of things, unless you have a very, very good excuse. Next slide, please. Appeal bundle needs to be served as soon as practical, and in any event within 35 days. You can see there those matters that it needs to contain. The appellant skeleton you can file at the time, so you can either draft, as many people do, a skeleton and grounds together, which is generally what would be expected at Court of Appeal, or alternatively you can actually file them later, which does give you a little bit of extra time to marshal your thoughts, and personally I find it more helpful. Respondent's notice, if one is to be filed, and for the most part in my experience in fitness to practice appeals, one doesn't tend to be necessary or used, would need to be filed unless the court grants permission otherwise within 14 days of service of the appellant's notice, and then again you have 14 days thereafter to file any skeleton argument. The benefit, if you don't need to, of not filing a respondent's notice, is you get an awful lot longer to think about how you're going to respond to the appeal and to submit any skeleton. Next slide, please. So moving on now to some practical points. Firstly, skeletons. The administrative court seems to be at times quite relaxed about the timings of skeleton, and perhaps more so than it might immediately on the face of it appear. And so it won't often necessarily take an issue with, for example, a replacement skeleton being submitted if it's necessary, or as I say, a skeleton being submitted comparatively late on in the timeline of the appeal. This, it should be noted, is very much in contrast to the expectations of the Court of Appeal, who have a rather more strict approach than sometimes you can get away with in the administrative court. Certainly in the administrative court, judges will sometimes not read skeletons a long time in advance of the appeal. I've certainly attended, and it doesn't seem that the judges read it until either that morning or indeed at all. There's no time limit for respondents to file skeletons by, as I say, technically, and you can get away with filing quite late. However, I'd suggest you're sort of taking your life in your hands a little bit if you decide to file anything later than 7 days, and prudence would dictate filing, unless there's a really good reason, some significant time in advance of that. Bundles, authorities bundles, try and agree those between the parties as soon as you can, and get them filed at court. It helps, unsurprisingly, for skeletons to be properly footnoted and referenced to assist the court. Ensure in the bundles that the authoritative and correct versions of the authorities used. All too regularly, you can see draft authorities bundles which the preparation of which looks as though it's been delegated and possibly has been rushed, and it's meant that occasionally an abbreviated version of an authority might appear within that bundle, or the wrong authority entirely, or just an authority from the wrong appeal or the wrong court within a series of appeals, so you get the High Court rather than the Court of Appeal. So just make sure that authorities bundles are checked carefully before they go off. And of course, the same approach to bundles applies to any bundle, whether regarding authority, involving authorities or otherwise. In the Court of Appeal, you have to have a core bundle and another separate bundle if it's necessary. It's an approach which you may wish to consider in the High Court as well, particularly in complex appeals, having a core and a supplementary bundle, as well as an agreed chronology. That can really help the court in understanding the issues in the appeal. If you're going to go down the route of using a chronology, which is mandatory in the Court of Appeal, then they should be detailed. They should not be vague at any point. They should be capable of being easily cross-referenced with the documents. Where there's abbreviations used, they should match with the abbreviations elsewhere within the bundles and in the skeleton arguments. And above all, they should be accurate. In terms of negotiations, they can seem a little bit shrouded in mystery, not least because you don't find out about them if they don't lead to anything, and even if they do. However, in principle, they're like any negotiation in civil litigation. Any regulator will always want to consider very carefully upon receipt of an appeal whether it's appropriate to fight it, because it's not in its interests to do so if it is a meritorious appeal. And there are a number of factors which play into a regulator's assessment of an appeal. So there's no harm as an appellant in seeking to, at least having allowed a little bit of time for the regulator to think on the appeal and take some advice, directly approaching the regulator to see whether or not it's going to consent to the appeal. Early settlement, of course, saves everyone cost and is in the wider public interest. Now, it may be that only partial settlement is possible, and there remains a dispute over the precise terms of the order, and that may be a matter that needs to be litigated at a later stage, and you still have to have a hearing take place, or it may even be that you can just deal with that on paper. Where you're getting into that position, it's important to ensure that the court is informed in case a listing needs to be vacated or shortened. Correspondence with the court, recognise that the Administrative Court Office is extremely busy, so don't expect it to be particularly responsive. And phone calls, you can very easily end up on the phone for some 15 minutes and never get a response. So ensure that is factored into the way that you conduct the litigation, and recognise, particularly with litigants in person, that you need to ensure that the other party is copied into all correspondence with the court. Occasionally, it would be better to correspond also with the judge's clerk directly, or at least include them if you're dealing with, for example, court orders, directions, and so on. Statements of costs, that's a really crucial document to get right. It takes a lot of time to fill in, and make sure you therefore allow for it. On summary assessment, it's going to be the only basis in reality that the judge has in order to determine what order to make. Try and make as clear as possible within that document where time has been spent and how. It can be helpful, if it's possible to get to understand what the other party's position is likely to be on the reasonableness of costs. But it's also important if there's going to be an oral application for costs at a hearing, so particularly if there's something like a strikeout hearing where you're applying for costs, to ensure that the attending fee earner at court really has knowledge at their fingertips of the way in which time has been spent and cost has been incurred in order to assist counsel in responding to any questions from the court. Ensure that you've checked that you've put down the correct rate for every fee earner, and also ensure that you've taken instructions on the VAT position. That can change, particularly most regulators don't pay VAT in the sense that they can't recover it from HMRC, but if the client you're acting for can, then it can't be double claimed. One tip is if you're billing at an hourly rate and you still want to try and recover the work that you do at court, because of course you've got to file the statement of costs in advance, is either try and estimate cost and make clear on the statement of costs what that estimated cost is before you file it, or alternatively, it may just be you have to take a calculator along with you on the day when you come to make your oral application. I'm getting quite close now to the end of my time, so I'll deal with two further matters. The first is practical problems at court. The main one I wanted to flag is things getting lost, which does seem to happen a little bit too much in the administrative court, and more than one might anticipate. I've had a case where I found that neither the correct bundle nor any skeleton argument has ended up with the judge, and I've had another one where no skeleton argument seemed to make it to anyone at all other than the respondent. Ever since then, I have always ensured that I've had spare copies of every bundle in the case and also of the skeleton argument, and that's something which I'd encourage anyone to do. Litigants in person. There are quite a lot of litigants in person when it comes to statutory fitness to practice appeals, and they create a number of challenges. Those challenges range from a lack of understanding of the process, can include documents that are difficult to understand, to simply being unreasonable in the way in which they deal with the lawyers acting for the regulator. Out of those, the two biggest problems tend to be poor drafting of grounds of appeal and poor documents generally. That's, of course, not surprising because the litigants in person, save in SRA and BSB appeals, are, of course, not trained lawyers. Now, as lawyers acting for the regulator, you bear professional responsibilities to the litigant in person. And in particular, that's going to include assisting the court in identifying any reasonable arguments that the litigant in person could properly have put during their appeal, but has overlooked. What is going to happen in a litigant in person case is the regulator is going to inevitably incur more costs than they otherwise would. Often, there will be many, many grounds of appeal, and because there's no permission requirement, they're not going to be sifted out at an early stage. You're going to have to do the lion's share of the work. You're going to have to identify the relevant law, and you're going to have to assist the court in identifying the relevant issues in documents such as skeleton arguments and so on. You're going to have to assist the litigant in person in understanding the process, in understanding the relevance of authorities, and the nature of the tests that the court is going to be applying when considering their appeal. Fresh evidence is something that regularly finds its way into litigant in person appeals, and that's something which you're going to need to clearly deal with as part of your response to their appeal. One thing I would suggest is give litigants in person a good lead-in warning about cost applications and the potential cost implications of the case that they're running, what the law is and what the application is going to involve. Don't just dump a statement of costs on them 24 hours before the hearing, because it will be perceived in all likelihood not only as insensitive, but potentially also as bullying or intimidating behaviour. And certainly, on that point, there really is nothing improper at all about being very supportive at court and elsewhere of the litigant in person. And when they're in court, they're bound to be anxious, possibly emotional, and proactively ensuring they know where they're going, what's going to happen, where they should sit, etc. Those sorts of things not only really helps, but it also helps create a positive relationship between you and the litigant in person. Next slide, please. The next few slides deal with procedure in the Court of Appeal. I invite you to look at those later on in your leisure when these get sent out. Practice direction PD52C is the one to look at in particular, and within that, the table that sets out the chronology of what should happen during a Court of Appeal case. That is something that you can almost print out and keep on your desk when you're trying to keep track of where you are and set your diary. The other important point to recognise is that if you do settle a case in the Court of Appeal, they will want to know very, very quickly, and in reality within 24 hours, that you've settled the case. And if you don't do that, then you're liable to be punished in costs for failing to do so. And then finally, I think we're 2 slides on, Ben, PSA appeals. They are a little bit different in character, of course, because there are 2 respondents to a PSA appeal. The issue to recognise in a PSA appeal is that insofar as representing a respondent is concerned, you're going to need to consider whether or not, firstly, you're going to resist the appeal at all. And a lot of that may depend on whether or not the regulator decides to. And then secondly, if you're going to be going it alone, and particularly if it's a case relating to under prosecution, then you're going to need to consider whether or not you need to file a respondent's notice. And if so, you've only got 14 days, unless the court extends time, in order to do that. In conclusion, really, running appeals requires a lot more attention than perhaps running a normal FTP case, and it does require assiduous compliance with the CPR. But in reality, from a wider civil litigation perspective, they're comparatively straightforward. Thank you.
Thank you very much, Guy. If you don't mind, I'm going to start off on the questions. So certainly I know there's a range of experience in our audience, and certainly something that troubled me at the beginning of my career, when you're dealing with an interim order ahead of any substantive decision. So an interim order and the registrant wants to challenge that. Is that by way of an appeal or a JR?
I can take that if you're content for me to. The answer is neither, for the most part. It's a specific provision in most legislation. Certainly there is in the Dentist Act, and certainly there is in the Medical Act, to be able to apply to terminate an interim order. So JR is inappropriate because there's another remedy, and an appeal is inappropriate because the remedy provided, albeit it looks a bit like an appeal, is not in fact an appeal. And it's a better remedy in many respects for the registrant than an appeal, because you don't have a time limit on it, bizarrely. So you make an application, you file the application via Part 8, you don't use Part 52. And I won't go into it now, but there's a certain amount of case law which assists you in the test of which the court needs to apply in approaching dealing with that. One thing that is interesting is sometimes you'll see that as a component part of a broader appeal, where somebody will tack on as part of their appeal a ground of appeal seeking to attack an interim order. So that will happen at regulators where, post a sanction decision, rather than imposing an immediate order, which is, for example, how the GDC deals with it in its legislation, you have to impose, in the way the NMC does, another interim order. And it doesn't change the proper way in which you attack that particular order. You still need, invariably, under legislation, to go under the Part 8 route rather than the Part 52 route. Technically speaking, it may be that the court is prepared to vary the approach if you've gone under Part 52, but technically it's a different remedy.
I mean, all I'd add to that is in situations where it isn't based on statute, there's always remains the ability to judicial review an interim order, but you would be, I don't think I've ever actually advised somebody that that's a good idea. So whilst in theory you can do it, the High Court are very, very reluctant to interfere in anybody's case management powers, absent of the most extraordinary behaviour. So yeah, although in theory it remains there, you probably would never want to use it.
Excellent. I think that clarifies the position for our guest. And the second question, I think probably for you, Ben, pre-action protocol letters, if one is not sent, is it fatal to your JR? And are there any circumstances that you know of where the court has accepted that they are not necessary?
Not sending a pre-action protocol letter isn't fatal, but it really depends on the decision that you're trying to challenge. So where you're judicially reviewing a decision-making body which has made a decision, or a court or a government body, anything like that, that's made a final decision, and there's no mechanism by which they can review that decision, then you don't need to send a pre-action protocol letter. So because there's nothing that body could do, they've made a final decision, has made themselves functus, then you can just go straight to judicial review and say, we're filing judicial review because you've made a decision and you've got no power to remedy it. In the regulatory proceedings, again, it would depend partly on the powers of the regulator and how they define it as to whether or not you can, whether the pre-action protocol letter is going to get you anywhere, because you've got to write to them and say, I want you to do the following things. And if they don't have, and if you know they haven't got the power to do that, then there's no point in writing that. And if you're not sure, then I would always send it out of an abundance of caution. I mean, one other thing I'd add in relation to the time limits is the 3-month time limit is pretty much, you're meant to do it as soon as possible, not necessarily within the 3-month time limit, but if you do it within 3 months, the High Court are not usually going to criticise you. And the traditional, or the standard format is a 14-day response to a pre-action protocol letter. But if you are only instructed 14 days before the 3-month time limit, you can truncate that pre-action protocol time limit. You can say, because the time limit is in 14 days, I'd like a response within 7 days. And in those circumstances, if you think you have a good judicial review, then I would consider whether you wanted to lodge a protective judicial review claim prior to the end of the 3-month time limit, to give the opportunity for the respondent to then either respond to your pre-action protocol response or then respond in summary ground format. But you should, if the deadline is coming up and you've got to make a decision, you need to decide on what the risk is in terms of lodging. But if you don't lodge, then you obviously have no jurisdiction. There's nothing you can do about it. Whereas if you lodge, you can always try and withdraw. You can withdraw from that with the permission of the court shortly afterwards if you need to.
And just one further point from me, and this is for either one of you, when it comes to litigants in person for either judicial review or appeal proceedings, other than dealing with them in a sensitive and proactive manner, is there anything else you can recommend to our attendees that's more important when it's a litigant in person case rather than it being against a regulator or body?
I mean, I've got one of these tomorrow. You probably have to provide more information when you're against litigant persons. So if you're against professionals, then the core bundle might be smaller. You might not include all the correspondence. You might fillet it so that you have only the most relevant documents. If you've got a litigant in person, they're they're probably not going to agree necessarily to you only putting in certain documents, but they won't necessarily understand which documents are the most relevant. And so in those circumstances, what I would tend to do is provide, as Guy said, a core bundle and say to the judge, this is what you need to read, but here is all the rest of the bundle, should the litigant person at some point want to refer to it. So you've got it all there, because the last thing you want, particularly now that lots of things are in electronic format, is the litigant person to produce a document from 7 months ago that you've got, that's not in a bundle and the judge hasn't got, and then you spend the next half an hour trying to get either a printed copy to the judge or email it to the judge can then read it, and it ruins the flow and the proceedings and the hearing. So it's worth just setting out how the structure of the case and the bundles slightly differently where you have litigants in person.
Thank you. I'm just going to check that there are no other questions in our Q&A, and I don't think there are. So that just leaves for me to thank both Guy and Ben for the very practical steps that you've set out in relation to appeals and JRs, and thank all of our guests for being here with us this evening. As I said at the opening, both the recording and the slides are going to be sent out to you so that you have them for hands-on use going forward. And good night to everyone. And if you're traveling, please do so safely.
Thank you very much.